In this lesson, we're going to begin our discussion of criminal homicide with a big picture overview of how the analysis works, kind of step by step at common law. Important to recognize, right, we're going to break all of these steps down in more detail as we progress through our discussion of criminal homicide. But I think it's important before we start getting into any of the specifics that we do understand from a big picture kind of what the flow of the criminal homicide analysis looks like, at least at common law. Right, so here we're really going to focus on the common law analysis. Of course, many of you might be wondering as we work through this where things like first degree and second degree murder fall into the analysis, right? Those are what we're going to call statutory modifications to the common law analysis. So once we have the common law analysis down, which is what we're going to focus on in this lesson and our next few lessons as we work through these steps, right, once we have this down, then we can add the statutory modifications on top of that and understand how to deal with distinctions between first degree and second degree murder, things like that in different jurisdictions. Right, so here we are going to focus on the common law analysis. Right, and again, we just want to do a big picture kind of overview of what the analysis looks like here. And so from the big picture, right, one of the good things about homicide and criminal law fact patterns is it's usually relatively easy to spot as an issue, right? Anytime we're looking at a criminal law fact pattern and we see that a victim is dying or being killed, right, we're all going to be able to immediately recognize, okay, we have to think about criminal homicide here. And we know that usually our ultimate issue is going to be whether the defendant is liable for criminal homicide. And usually we're applying the common law, right, in law school and on the bar exam. Right, we're usually applying the common law unless the fact pattern tells us otherwise, right? The fact pattern gives us some statutory modifications to work with. But because the common law is our default most of the time in law school and on the bar exam, that's what we're going to focus on here. Right, so the first step we want to think about anytime that we see a victim dying, and I guess before we actually get into the steps, just to make sure that we're all on the same page, I think we all probably know this, but just to verify, right, when we're thinking about homicide, right, just to give an actual definition here, at common law, a homicide is going to be defined as a human being killing another human being, right? One human being killing another human being, right? The killing of another human being is really our common law definition of homicide. So one thing that definition takes kind of off the table is suicide, right? Suicide is not homicide. Homicide, we need one human being killing another human being. So if a person kills himself, he cannot be held liable for criminal homicide. Suicide is not homicide. Another important note to make here, just from a definition perspective, is a homicide by itself is not necessarily criminal, right? There are lawful ways one human being can kill another human being, right? Think about the state, right? A state that is executing a prisoner, right, as capital punishment, right? If a state is lawfully doing everything by the book, right, eventually you're going to have the executioner, right, one person killing another human being. That is a homicide, but it is lawful, right? That's not a criminal homicide. Think about a doctor taking a patient off of life support with consent of the family, right? That would be the doctor, a human being, killing another human being, right? That's homicide, but it's lawful, right? It's not criminal homicide. So what we're really focused on here when we're thinking about, okay, then what's the definition of criminal homicide? If a homicide is one human being killing another human being, criminal homicide would be the unlawful killing of another human being, which is what we're really getting at here in our analysis, right? What is the unlawful killing of another human being? When can the defendant be held liable for criminal homicide? And again, we're going to focus on the common law here. So with that out of the way, step number one, right? Anytime we're looking at a criminal law fact pattern and we see a person dying, right? We have a victim who has died or a victim who has been killed, right? Step number one, first question we should always ask when we're thinking about whether the defendant is liable for criminal homicide is whether the defendant's voluntary act or omission that constitutes the actus reus of the crime was the actual and proximate cause of the victim's death. Right? In other words, did the defendant cause the victim's death, right? And remember, we talked about this in a ton of detail in our last lesson, right? When we talked about the causation requirement as an essential element. Remember, we broke down all those examples, we had the timeline on the board, and we talked about all the different examples between the differences between actual and proximate cause, right? That's our first step, right? In order to determine the liability of a defendant, we want to make sure, right, of course, that the defendant is actually the actual and proximate cause of the victim's death. Because if the defendant did not cause the victim to die, right? If we can't find that causal link between the defendant's conduct and the death of the victim, right, then the defendant cannot be held liable for criminal homicide, right? Because intuitively, we can just think in our heads, well, hey, look, if the defendant did not cause the victim to die, then we can't hold the defendant liable for the victim's death, right? We need that causal link between the defendant's actus reus, right, that voluntary act or omission, and the ultimate death of the victim, right? And remember, kind of an example we talked about there where you could have issues with causation is usually when the defendant, right, does something that inflicts an injury, and then after the initial injury is inflicted, other things happen on the causal chain, and then our victim dies, right? So imagine one of the examples we used, if you remember, is imagine that the defendant shoots the victim. Let's say that the bullet grazes the victim's ear, right? And the victim gets onto an ambulance, right? An ambulance is called to the scene. Victim's riding to the hospital to treat this bullet wound to their ear, right? They're in the ambulance going to the hospital, and a meteorite falls out of the sky, crashes into the ambulance, and kills the victim on impact. Right there we would say, look, maybe the defendant is the actual cause of the victim's death, right? The victim would not have died but for the defendant's voluntary act of pulling the gun, right? If the defendant had never shot this person, they would have never been in the ambulance. They would have never been hit by the meteorite. The problem is we can't show that the defendant's voluntary act was the proximate cause of the victim's death. We would say that meteorite falling from the sky was so abnormal, so unforeseeable, that we're not going to hold the defendant criminally responsible from that point forward. Remember, we called it a superseding cause that breaks the chain of liability. All right, so what we're really looking for when we're thinking about step one is anything that happens on that causal chain out of the ordinary, right? And remember, with actual cause, if we have multiple defendants involved, we could have actual cause issues. But what we see really commonly as an issue is when these unforeseeable events happen on the causal chain, right? That's what we're really looking out for here in step one. And remember though, a lot of times we said this analysis can be just instant in our head, right? Compare that example to a defendant just taking out a gun, right, and pointing it at the victim's head, pulling the trigger, bullet hits the victim in the head and kills the victim immediately. Well, in that case, we don't have any causation issues. It's very abundantly and obviously clear that the defendant's voluntary act was both the actual and proximate cause of the victim's death, right? We don't even really have to worry about step one and those types of fact patterns. What we're looking for is attenuating circumstances in that causal chain, right? We really want to be cognizant of when we're thinking about step one in determining whether the defendant is liable for criminal homicide. Right? Another nuance here is a common law rule called the year and a day rule. Right? At common law, a defendant could not be liable for criminal homicide unless the victim died within 1 year and 1 day of the act that inflicted the fatal injury. So essentially, this common law year and a day rule puts an actual time limit on our causal chain, right? If you remember from our last lesson, that big timeline we had drawn on the board, and we talked about different things that could happen during the timeline, right? Under the common law, right? Under the year and a day rule, that timeline actually has a finite set time limit on it, right? Of a year and a day. So under the common law, if a defendant shoots a victim, right, and that victim goes to the hospital and they fall into a coma, and a year and 2 days after the gunshot, a year and 2 days pass from the time the defendant pulled the trigger that inflicted the original injury, right, the fatal injury, if a year and 2 days pass before, right, that victim dies, the defendant at common law could not be held liable for criminal homicide, right? They'd probably be liable for something else, but they're not liable. That defendant is not liable for criminal homicide because the victim did not die within 1 year and 1 day of the act, the gunshot that inflicted the fatal injury. Right, so just one nuance to consider when you're thinking about step one. At common law, we do have the 1 year and 1 day rule, right? We need the victim to die within 1 year and 1 day, essentially, of the voluntary act or omission that constitutes the actus reus of the crime in order to hold the defendant liable for criminal homicide. Again, and an important takeaway, you're going to keep hearing me say it over and over and over again. Just because the defendant's not liable for one crime doesn't mean the defendant can't be liable for a different crime. So in those situations, right, defendant would probably be liable for something else, just not criminal homicide, right? So once we get past step one, we have to move on to step number two, right? So after step number one, if we find that the defendant is the actual and proximate cause of the victim's death, right? Defendant walks up, shoots somebody in the head, they die immediately. Okay, obviously the defendant is now the actual and proximate cause of the victim's death. In other words, at that point, we can really kind of say in our own heads, right, well, that means if the defendant is the actual and proximate cause of the victim's death, essentially, that means the defendant did kill the victim, right? In our heads, we can think of it as, okay, we now have a killing, right? The defendant has killed the victim because the defendant is the actual and proximate cause of the victim's death. Of course, if we don't have that, if the defendant was not the actual and proximate cause of the victim's death, then the analysis ends right here. Right, then the defendant is not liable for criminal homicide. The defendant's not liable for murder, not liable for manslaughter. If the defendant is not the actual and proximate cause of the victim's death, we can stop at step one. Defendant is not liable for criminal homicide. Now, if we find that the defendant is the actual and proximate cause of the victim's death, again, that basically means that the defendant killed the victim. Our next question has to be, well, did the defendant commit the killing with malice aforethought? Because if so, we can say that the defendant is liable for common law murder absent mitigating facts. Right, so we'll see at common law, we really have two major categories of criminal homicide, right? We have murder and we have manslaughter. Murder is our more serious offense. Manslaughter is a less serious offense, right? Meaning murder at common law is usually going to have higher punishment than manslaughter, more years in prison basically than manslaughter would, right? So the recommendation would be, let's start at murder. See, once we know basically that the defendant is the actual and proximate cause of the victim's death, we can say, okay, look, the defendant killed the victim here. We have a killing, one human being killing another human being, right? The first question has to be, is this murder? At common law, the way we make this determination is by asking whether the defendant committed the killing with malice aforethought. If so, right, that's going to tell us that the defendant is liable for common law murder, not manslaughter, unless we have mitigating facts, right? And we'll see what the mitigating facts could be in the rest of our steps. But question number one, once we establish from step number one, right, that the defendant actually killed the victim, our first question in the analysis between kind of murder and manslaughter is going to be whether the killing happened with malice aforethought, right? Did the defendant commit the killing with malice aforethought? Before we jump into what malice aforethought means, it's very important to recognize that this language is misleading, right? When students hear the words malice aforethought, the inclination is, oh, that means premeditation, right? We're looking for a premeditated killing, and that is 100% incorrect, right? The actual language here you should almost ignore, right? Malice aforethought is just a legal term of art, right? The actual meaning of the words malice and aforethought, those dictionary definitions are irrelevant in the analysis, right? Even though that kind of sounds like premeditation, that's not at all what we're talking about here, right? So malice aforethought is just a legal term of art. Don't get confused there, right? So what does malice aforethought mean? Well, we say at common law, a defendant commits a killing with malice aforethought if he does so with any of the following mental states, right? Intent to kill a human being, intent to inflict grievous bodily injury on another, reckless indifference to an unjustifiably high risk to human life, or depraved heart murder, or intent to commit a felony, otherwise known as the felony murder rule. So important to recognize, we're going to break each of these down in a ton of detail in future lessons. But what we want to understand here is that malice aforethought is essentially a mental state requirement. If any of the following 4 mental states existed at the time the defendant committed the killing, then we say it's common law murder, right? Unless there are mitigating facts, right? So we can break each of these down a little bit just to give an overview and then keep going here. Thank you so much for watching this video preview of our Legal Education Accelerator Program, or LEAP for short. If you would like to see the conclusion of this video and gain full access to our entire 1L and 2L video library, integrated outlines, streamable audio versions, additional practice exams with explanations, and much more, we invite you to head over to our website and join the thousands of law students who have already enrolled. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com/leap.
Hi everyone, my name is Serena and I'm currently a law student at South Texas College of Law, Houston.
Hi everybody, my name is Shiva and I'm currently a law student at Southwestern.
Hi everyone, my name is Michelle and I am a first year student at South Texas College of Law, Houston. I used the Studicata study video series last semester to help me prepare mostly for contracts, and I actually made an A+ in contracts last semester, which I greatly dedicate to the Studicata videos.
By using Studicata to help me prepare for my final exam, I was able to score the highest grade out of my class on the final and even have my essay distributed as the model answer. Not to mention I had done quite poorly on the midterm and was struggling throughout the whole course of the semester, understanding the material and keeping up with lectures.
Because of the Studicata video lectures, I was able to go into my exams with a feeling of confidence. I didn't have to worry about what the rules of law were or how I was going to organize my answer to an essay question.
I would absolutely recommend the Studicata series and their online course materials to anyone. I think that they are not like professor lectures that you might find online or other outside study materials that you may encounter. I think that the Studicata videos really focus on not only ensuring that you understand the material that you're going to encounter on your final, but they also help you to understand kind of the best method for test taking, and they really break down how to approach each problem and the best ways to tackle certain methods on testing, and I think that's really important, and I think it's really special. I don't see that anywhere else in any of the other online resources that I've found. So I would certainly recommend Studicata to anyone who is studying in law school right now. Good luck on your studying, and you're going to do great.
I I would definitely recommend Studicata to anybody watching this video. Give it a chance. I'm positive that you will love it, that you will get a lot out of it, and that you will be happy that you gave it a chance. I definitely am. I know I will be using Studicata in the future.
And I cannot thank Studicata enough for getting me through my first semester of law school. I will definitely continue to watch the Studicata video lectures throughout my law school career, and I highly recommend that any future or current law student do the same.